Hello, everyone. Welcome to PLB, Professional Languages of Brazil. Today, we are going to talk about the British Constitution, the UK Constitution. After my explanation, you are all welcome to participate in our Q&A session, where you will be able to ask questions on this subject. This lesson is being recorded and will be available on our platform from tomorrow onwards. So the first question is, what is the UK Constitution? Constitutions organize, distribute, and regulate state power. They set out the structure of the state, the major state institutions, and the principles governing their relations with each other and with the state citizen. Britain is unusual in that matter because it's got an unwritten constitution. Unlike the great majority of countries, there is no single legal document which sets out in one place the fundamental laws outlining how the state works. So that's the biggest difference between the UK Constitution and other constitutions throughout the world. Britain's lack of a written constitution can be explained by its history. In other countries, many of whom have experienced revolution or regime change, it has been necessary to start from scratch or begin from first principles, constructing new state institutions and defining in detail their relations with each other and their citizens. By contrast, the British Constitution has evolved over a long period of time, reflecting the relative stability of the British polity or policy. It has never been thought necessary to consolidate the basic building blocks of this constitution, of this order in Britain. What Britain has instead is an accumulation of various statutes, conventions, judicial decisions, and treaties, which collectively can be referred to as the British Constitution. It is thus more accurate to refer to Britain's constitution as an uncodified constitution rather than an unwritten one. It has been suggested that the British Constitution can be summed up in 8 words. What the Queen in Parliament enacts is law. This means that Parliament, using the power of the Crown, enacts law which no other body can challenge. Parliamentary sovereignty is commonly regarded as the defining principle of the British Constitution. This is the ultimate law-making power vested in a democratically elected parliament to create or abolish any law. Other core principles of the British constitutions are often thought to include the rule of law, the separation of government into executive, legislative, and judicial branches, and the existence of a unitary state, meaning ultimate power is held by the centre. The sovereign Westminster Parliament, however, some of these principles are mythical. The British Constitution may be better understood as involved in the fusion of executive and legislature. Or, in doubt, parliamentary sovereignty may now be called in question given the combined impact of Europe, devolution, the courts, and human rights. The British Constitution is derived from a number of sources. Statutes are laws passed by Parliament and are generally the highest form of law. Conventions are unwritten practices which have developed over the time and regulate the business of governing. Common law is law developed by the courts and judges through cases. The UK's accession to the European communities Act 1972 has meant that European law is increasingly impacting on the British Constitution. The UK is also subject of international law. Finally, because the British Constitution cannot be found in any single document, politicians and lawyers have relied on constitutional authorities to locate and understand the Constitution. An uncodified Constitution creates two problems. First, it makes it difficult to know what the state of the Constitution actually is. Second, it suggests that it is easier to make changes to the UK Constitution than in countries with written constitutions, because the latter have documents with a higher law status, against which ordinary statutes, law, and government action can be tested, and are only amendable via elaborate procedures. The flexibility of the UK Constitution is evident from the large number of constitutional reforms since 1997, including the abolition of the majority of hereditary peers in the House of Lords, the introduction of codified rights of individuals for the first time in the Human Rights Act 1998, and devolution to Scotland, Wales, and Northern Ireland. Arguably, however, these recent constitutional reforms may have made the Constitution less flexible in some respects. It is debatable, for instance, whether the devolution settlement could ever be repealed. Now I'm open for questions. You all have 2 minutes to ask questions, or let's make it 5 minutes. So I'm out to help you all right now. Have you any questions? I'll be waiting for you. I'll be looking forward to hearing from you here on our website or on Google Hangouts. Okay, and that's all from me now, and I'll see you next time. Bye bye.